Islamic banking, Ijarah is frequently utilized as an alternative to traditional leasing. The word Ijarah is derived from the Arabic word Ajara Ujuru, which derives meaning of renting. It involves by one party, which is the lessor, called as bank, and another party, which is the lessee, called as customer, to utilize the benefits on a physical asset for rental consideration. Because interest-based financing is forbidden in Islam, it enables Muslims to obtain assets or equipment. Under an Ijarah contract, the lessee has the right to use the asset for the predetermined time and rental amount, but the lessor retains ownership of the item. One of the major challenges in implementing the Ijarah contract is change of rule. New government policies and economic conditions frequently result in changes to Islamic banking legislation. These modifications may create uncertainty. For instance, changes in tax laws may have an impact on calculation of rental payments. In this situation, Islamic banks must modify the terms of their Ijarah contracts to ensure that taxes are paid accurately while adhering to Islamic law. This is not always easy and requires careful planning. To solve this issue, Islamic banks must formulate active and dynamic policies. They have to keep a careful eye on new laws or regulations. This facilitates their ability to quickly adapt as needed. Other than that, staff training is also important. In order for employees to effectively manage the Ijarah contract, they should be aware of how these regulatory changes impact it. Lastly, there should be active communication between regulators and Islamic banks. They can provide their input ahead of time and be updated on changes by doing this. Another serious challenge in implementing Ijarah contract is legal uncertainty. This occurs when the laws dealing with Ijarah are confused or subject to various interpretations. It can lead to conflicts between the bank and the clients and put Islamic banks at legal risk. For instance, it may not be clear who is in charge of asset maintenance. The application of national law and the interpretation of Sharia law might occasionally differ. This difference can lead to conflicts, increase legal costs, and reduce trust among investors and customers. As the Islamic banking industry grows, these problems can become more serious. That is why it's important for Islamic banks to create clear, understandable Ijarah contracts that leave no room for misunderstanding. All information must be made clear, particularly on rights and obligations, such as who is responsible for maintaining the assets and who bear the cost. Islamic banks should work closely with Sharia-compliant legal when writing contracts in order to minimize legal confusions. These specialists are able to ensure that agreement complies with both national and Islamic regulations. By doing this, banks can maintain their clients' trust in the systems and protect themselves from legal issues. The last issue is there are concerns regarding agreement repurchase assets at original price, which is face value. According to Islam, investment that include risk and profit loss sharing, which is similar to riba, cannot completely protect capital. This arrangement can be changed to an exchange of money for money because the assets are not really given to the sukuk holder. This results in delay riba and goes against the purpose of Islamic muamalat. The primary goal of Islamic business dealings is rawaj, or genuine commercial activity, which does not promise profit without risk. The Islamic investment principles of transparency and share risk are compromised by such a structure. To solve the issue of capital guarantee in Sukuk al-Ijarah, one suggested solution is to exchange agreements to repurchase the assets at market value or an agreed upon amount at the time of repurchase. By doing this, a guaranteed return is avoided and the price is guaranteed to reflect the asset's true condition. In conclusion, even if the Ijarah contract offers a Sharia-compliant option for conventional leasing, there are still a number of significant challenges to overcome before it can be put into practice. For suku al-Ijarah to be compliant, and sustainable issues such as change of rule, legal uncertainty, and Sharia concerns must be carefully considered. To address these obstacles, Islamic banks need to implement flexible rules, make sure that contract conditions are clear, and work closely with Sharia and legal professionals. By doing this, they may preserve public confidence and foster the growth of the Islamic banking sector while upholding the fundamental principles of Islamic finance, which are fairness, transparency, and risk sharing.